Yes.
Adjournment request, if any, from item number 1 to 8.
Nobody.
From item number 1 to 8, adjournment request? No. From item number 9 to 16?
Yes.
My apologies, Lordship. Actually, in item number 9, Mr. Hegde is leading the case. Yes,
Yes.
some sudden inconvenience, Lordship. So kindly, that will be taken up some other date, Lordship.
As paid for on behalf of the petitioner on account of unavailability of the senior advocate who is to address this court. Let this matter come up for consideration on give a date in February. Yes.
24th February.
Much of it.
May I please your Lordship? With the consent of the other side, I beg to mention item number 14. Kindly
14.
matter may be fixed
14 is
on
adjourned. German slip has been circulated.
after vivification hearing.
All right.
19th February.
Very pleasure, Lordship. Lordship, I beg to mention item number 17, Your Lordship. Lordship, learned arguing counsel is out of station.
Adjournment slip has been circulated. Give-
2nd March. From item number 18 to 51, adjournment request. Any other request?
Hey, please, Your Lordships. Your Lordships, in the item number 6, we had filed an additional affidavit in opposition yesterday.
Yes.
So kindly call for that affidavit.
Yeah, can we call?
Obligement.
Please have it.
May I please, Lordship? Lordship, I am praying for listing of an appeal, Lordship. Our next promotion as executive engineer is overdue, Lordship, but only because now some vacancies have occurred. And only because of the pendency of the appeal, Lordship, we have not been promoted, Lordship. Immediately after the vacation, Lordship.
All right.
20th
20,
January. 20.
20 then.
Daily list for orders item 1 to 4.
Yes.
Lord, we'll be filing the review before the Honorable Apex Court within this week itself, my lord. And my lord,
Review
yes, my lord. Because
is.
I'll
I
just,
think that will be a curative or review.
it's a review, my lord. Lord, the reason I'm saying, my lord, I'll just want your lordships to go through the judgment of the Honorable Apex Court.
Now, why do we go? Why they have decided that 31st of March, if anybody retires, he would be considered to be a person in service. I mean, the
No,
pension rules would apply to him.
The Honorable Apex Court has held basically that although rule have, my lord, the 31st March 2016, who have retired, they will be entitled for benefit of revision. Lord, this is
Anyway,
in,
what do you want?
my lord, at this stage, my humble prayer, lordship will give me some time. Let us see what the review, what happens to the
When
review.
did you file the review?
My lord, in this week itself, my lord, during the vacation,
This week is a big time.
within this week, because why I'm saying that after the last listing, there was a vacation, my lord. In our department, it takes some time.
We can't deprive your friend.
No,
from
they have
taking-
already, look, financial benefit.
They have got.
Yes, my lord. Payments were already released.
As prayed for on behalf of the appellant / Assam Power Generation Corporation Limited and others, let this matter come up for consideration on.
Look,
We'll
after
give
a
you
month,
time
my
in
lord.
March.
After a month, yes, man. Highly obliged.
My lord, in view of.
You've got the financial
Yes,
benefits.
yes,
No,
because-
don't worry. Let's see. I don't think there'll be any new order in review.
Yes, my
Look,
lord, just,
I hope this view changes, my lord.
I know the view of the honorable judge who has passed the case.
may I just point out one thing, my lord. That if your lordship peruses para 18 of the Honorable Supreme Court's order, the Honorable Supreme Court has restored the single judge's order. And this Honorable Court has stayed it, my lord. So that interim order
No,
will be vacant.
they have already released. The payments
no.
were,
We must do that. The interim orders, in view of the judgment of the Supreme Court
fine, man.
in so and so details, like, this detail. In view, the interim order passed by this court stands vacated.
Fine,
Deeply,
fine.
Thank you for reminding us.
deeply. Aware.
5th March.
Highly obliged.
5/3.
5th of March.
Item 5,
No, no reply. 116.
Yes, why don't you reply? 1162 days delay.
Lord, we'll reply, my lord.
Again. Mr. Nath,
Lordship. Except 5, my lord, other respondents I am appearing, my lord,
and council appearing for response number 1 to 4
and 6,
and 6
6.
submits that he'll be responding to the application seeking condonation or delay of 162 days in preferring the appeal.
1936, my lord, they said.
Huh?
1936 days, they said.
1936 days in,
Yeah.
Acha, my note is 116. So many days delay in preferring the appeal. Let notice also be issued in the meantime to respond number.
5 is here.
You're appearing.
Yes, 5.
So you would file your affidavit on behalf of Mr. So-and-so learned advocate who has appeared on behalf of respond number 5 shall also put in his response affidavit by the next date, re-notify February 1st week, 2nd week. wherever-
11 March or 11 February, sorry.
All right, my lord.
Item number 6 to 8,
They have filed the affidavit. They're saying that they are not adopted the rule of 2023. That's what they have.
My lord, will kindly see the advertisement made in paragraph.
We are not aware. You have to remind us. Don't just
Your
start.
lordship, what happened is that
No,
this
where is the last order?
last order, your lordship will kindly come to 6 August 2026 order,
6A.
6/8. Your lordship,
1 second.
I copied it. Copy to this one.
The Supreme Court says that needless all content accordingly they specially dispersed as withdraw the liberty to withdraw the present appeal, liberty to file an appropriate application before the court. Now look at paragraph 7 of the order passed by this court, which you challenged before the Supreme Court and it was rejected.
my lord. Your lordship, the P. Nayak Learned Standing Council BTC, however, submitted that the advertisement in question is only with respect to 6 months training at the Assam Survey and Settlement Training Center for the purposes of appointment on the post of land record assistant. Till date, the Learned Standing Council BTC has argued no decision has been taken to debar such candidates who have successfully obtained proficiency certificate of recorders class course training under the earlier 1992 rules. However, looking at the advertisement at Annexure 4 to this writ petition, it appears that the training under the new rules of 2023 would enable the candidates to appear against the existing probable vacancy of the post of Lot Mandal land record assistant likely to fall vacant up to 31st January 2026 to the exclusion of the petitioners. A detailed affidavit in this regard would be required for this court to close this petition. The affidavit
All
would,
right, just,
Yes.
so where is the
We-
affidavit?
We have filed an affidavit. Delivered.
Have you served a copy to him?
my lord. they have
Yes,
sub-
yeah. In view of paragraph 8 statement, my lord, this can be closed, my lord, wherein specifically it has been
Paragraph
stated.
8 is what?
8 of the additional affidavit filed on 5/1, my lord.
Read it out.
Yes, the deponent states that the new BTC government is actively considering for enactment of its own rules for the purpose of appointment and service regulation of cadre of LRA and others, subject to approval of the government of Assam as per the requirement of law. Further, as government of Assam, wide notification dated so and so has provided for the candidate who have successfully completed RCC training prior to enactment of the rules of 2022 to appear in the examination for the recruitment of LRA as one-time measure. The BTC government, while electing its own law, shall consider in similar manner, my lord.
No, my lord, the reason for,
So we have followed that.
my lord,
But presently, there is no need to stay the advertisement.
yes,
You know, the purpose is that you're not losing out. You are qualified.
my lord,
The rules of 2023 would require a fresh qualification for somebody to undergo that training.
my lord,
Yeah.
So you don't require that.
my lord.
You are already trained.
I have already trained.
That's all right. So they make a statement that they are not going to debar you.
No, that will suffice for item
Why
number
are
six.
you arguing then?
6 and 7, I'm fine, my lord. 6 and 7, I'm fine. Item number 6 and 7.
What do you want then, Mr.
No, no,
Burgoyne?
my lord, when we approach this honorable court, at
Tell
that
me
time,
one thing, what you did in the past is something else.
my lord, I am satisfied with this
Ah,
condition.
Therefore, we close this
With
petition only.
6 and 7, yes, my lord. But 8 is writ appeal. That's a different. 8 is writ appeal, my lord. 6 and 7 can be closed. Item 8.
Let's see it.
Your lordship will, serial number 8,
This is WA number 209.
my lord.
Yes.
Your lordship, in this matter, what happened was that we were being approved by the BTC. We have been proposed by the BTC and the Assam government has approved us that you people will, 219 candidates will go for RCC course. When this was pending, when we approached for joining for course, another 150 number of candidates have been selected. The BTC, the principal secretary said that this 150. That is the matter which is pending before we approached the read court. Read court said that no, 150 will be applicable. 219, your process was opaque. Yesterday, while I was going through the brief, your lordship, the stand taken by the state respondent and the stand taken by the BTC are too conflicting because the government of Assam is saying that yes, these were the 219 list candidates who have been approved by the government of Assam. So yet in item number 8, I believe my learned friend also has to have a proper instruction.
Yes.
Item number 8.
I need the instruction for that.
Have you responded in item number 8?
No, my lord. This is for the first time it has come up, my lord. I'll take the instruction on the next date, my lord.
Take instructions on that day only 6 and 7 would be closed. 8 will decide.
My lord.
Yes, that can be.
Let all these matters come up for final determination on the date in February, mid-February.
19 February.
Pardon?
19 February.
19th February.
Obligation.
Published.
6 and 7, there is no problem.
No problem, my lord. Even
No,
today also
this-
it's been closed and I'm going to push.
This would require a appeal.
Going to Supreme Court helped me with getting this affidavit, my lord. Obliged, your lordship.
Item number 10,
Result prevailed. Are all parties here? Are all of them here?
So was the government official respondent? No, the private parties are there, but the official respondent,
No. Official respondents, who all are there?
Mr. Talukdar is appearing.
And Mr. Talukdar is appearing for whom? Acha, you represent him. All right. And Mr. Banik, you
Out
represent,
before respond number 6, 8 to 13, 15 to 19.
and how about others?
I respond number 5, madam, on behalf of Mr. M.K. Sharma, M. Sharma, is available.
All right. And the rest of the respondents? So the election results have been revived.
Yes, my lord. Lord, the registrar,
Now, but let all the
Refuse-
respondents be here. See, the single judge appears to have passed this judgment. And the prime consideration to our mind is that there is a constitutional obligation, not constitutional, but statutory obligation on one-man committee to constitute. And therefore, without any evidence, the registrar, who was that? The
registrar of cooperative
the
societies.
Cooperatives ought not to have cancelled the elections. That's the sheet anchor of the judgment.
The learned single judge, look, in the impugn order,
How do you question that? The evidence definitely is very sketchy.
look, the evidence was there before the registrar because we,
When the matter was pending before the court, look at this.
yes,
Now come to paragraph.
lordships, I think lordship will kindly have the impugn order before the single judge.
Service also is not complete. That will see. My brother is telling me that service is not complete. We'll await the completion of service. But then on merits, can you, Mr. Das, question this? One is for the
No,
cooperative
if your
department.
lordships kindly see the impugn order before the honorable single judge,
No, we are looking at the impugned judgment.
lordships, fine.
Why do we travel beyond? Now you question this.
Yes. Look, the honorable single judge has laid credence on one aspect that they got elected uncontested. So whether the electoral roll was
You're shifting the
No.
importance given to other points.
fine, Milord, there are other points
You
also.
can't substitute, we can't substitute our wisdom for the single judge, no?
No, I'm not saying
We
that.
can only test whether he was correct or not.
The learned,
No, we find, just a minute.
yes,
One, no affidavit was filed on behalf of the corporation department.
yes, that was the Milord.
The registrar of the cooperative societies disproved the elections AGM held on the basis that many shareholders had signed the attendance sheet twice and the signatures were found against dead shareholders. But nothing mentioned in the impugned order as to how even assuming the observations to be correct had materially affected the uncontested elections. That's very relevant. That's very relevant.
True, Milord. Because,
Uncontested.
Milord,
Therefore,
this,
somebody, just a minute, somebody would have been there. See, not all shareholders, but correct voters nobody came, so there was no occasion for anybody to vote. Uncontested.
Out of double to double
No,
nine shareholders,
that is-
359 was present, quorum was met,
Suppose
14
out of
uncontested.
1059, there were, out of 1059, there were 59 bogus, dead people.
that is
Doesn't
why,
matter.
that is
Doesn't
why,
matter.
that is why.
But then nobody came to contest them, no? Therefore, what evidence? I mean, where has the single judge gone wrong?
Milord, I'll have to place the facts because, Milord, I'll just explain.
Mr.
I,
Das,
I'm addressing your lordship's query, Milord.
see, I am not closing the window on your face today.
I understand.
I'm not closing it.
I understand.
But you need a very, very strong force to unhinge this.
Yes, my lord. I'll satisfy your lordship. Why I'm saying so? The learned single judge has given extreme credence to the fact that they got uncontested. They got elected
We are
uncontested.
saying so. And
Yes.
we are not willing to travel.
I am, my lord, I am hitting this conclusion derived by the honorable single judge on the context that the uncontested election, winning the election uncontested comes later. Prior to that, there are statutory requirements which you are to fulfill. Section 26, Rule 7, there is a mandate. That process will culminate.
That's right. Come to para 26. That's the answer.
Para 26, Honorable Single Judge derived conclusion that these are sweeping remarks. There were no details given. Impugn order, Milord, the impugn order came into existence after a hearing by both the parties. We produce material before the registrar. Those materials are there before your lordships in our affidavit also, wherein we have specifically, Milord, demonstrated there that at least there were 35 voters who were either dead or their signatures were given twice. is it not blatantly, my lord, apparent on the face of the records that there was, my lord, that's why, my lord, our contention before your lordships is that it is not your statutory duty to correct the voter list. Section 26 clearly provides for that.
And single judge was not sitting in appeal. Therefore, what was there in the order of the registrar, that was considered,
My lord, my humble,
not the material.
when the
Anyways, let the pleadings, let all be served. All are left to be served.
I'm told by my brother, there was an order dated 31/10/25.
In respect of other respondent, service is complete. Oh. Who is not being represented?
No, Robona, by the way.
There's nobody else.
Nobody else.
7 and
If you
14,
say so, then we hear and conclude this.
7 and 14, my lord, deemed to be valid.
7 and 14 deemed to be valid.
Yes,
8, 9, 10, 11, 12, 13. And rest all are here.
yes.
Chaliye, then you argue. Then I think today only you'll have to make that effort. You want it to be argued on some other day, we can give you that time.
Better. Look, after Bihu,
And only one thing I'll just point out.
let my friend,
It's okay, it's okay, I'm not on the merits, but there's an order which they have annexed by which the assistant registrar in charge has directed that the share given to her be struck out. That order is neither under challenge nor pleaded in the affidavit
that has-
sworn by them in the
my lord,
requisition.
that aspect has been,
Absolutely, this is, I mean,
Lord, my
curtain
friend
was
is
drawn
going
on that.
somewhere else, my lord.
no, it is a fact.
He's,
You don't have that locus to
he's-
find the appeal.
he challenge, my lord, I'll satisfy.
On the
My lord,
merits,
I'm not that,
you be
my lord,
clear on that.
I'm that much vigilant that I'll not come before your lordship
It's not
without my
pleaded.
locus.
It's not pleaded. So
Let him have the satisfaction of
Right.
arguing that, my lord, but I can satisfy your lordship.
Immediately after view kar dete hain. We'll put it immediately after view.
my lord.
Fine.
Okay. The, make sure that all of you are present on the next.
Yes.
Mr. Das perhaps did not know that the court will take this view.
No,
You will have to first demolish this judgment.
I'll,
I will not go beyond.
your lordship will not be required to go beyond this. I'll satisfy your lordships. I'll satisfy your lordships with regard to power of judicial review also. When the order is apparent on the face of the record, the impugn order,
The judge has not lost track. He knows that there are some dead persons who are there in the voter list. Objections were raised, nothing came out. And then these people, the primary concern was that the one-man committee had a statutory obligation to have it constituted. So therefore, taking that into account, the registrar could not have acted whimsically. That 35 persons were not there. So those 35, barring 35,
then again we
then
are,
others that voted. These statutory responsibilities in Department of Cooperation, you also know, we also know. Otherwise, the entire purpose gets defeated of the elections.
my lord, does it mean, my lord, say for example, I'm placing an example, my lord. One of our district judge is required to, my lord, issue an advertisement, written examination and viva voce, then the result.
That example would be inapt. You first find out how to dislodge this.
Yes, yes, ma'am.
I would expect him to have the
conclusions.
frame of reference.
See, the filtrate of the judgment is that there was a statutory obligation. That obligation was fulfilled. The members got elected, the persons got elected uncontested. Therefore, this would not have sullied the election result.
My lord, I'll
You argue that.
address regarding statutory remedy.
And then again, judicial review is all right. The single judge was not sitting in appeal. Like anything what the single judge does, we sitting in appeal, we can look into the facts. But here, prima facie, the decision was not backed by logic, by acceptable logic, and therefore the order of the registrar was set aside. We are on that.
I understand.
So, considering the fact, we take it into account. Now,
Yes.
we have not seen anything. This would not have been in your contemplation while making preparation. We give you another time. You talk about
Fine,
this. This is
fine.
not a review.
Fine.
Grateful. Blessed.
Grateful.
When have you kept it?
22nd January.
20?
22nd January.
Would it be?
Can it be
Yeah,
27?
in February 1st, 2nd, Milord. I might not be in town 3 days, Milord. Second. Obliged.
2nd February.
Yes.
Fine. Much obliged.
Item 11 and 12.
ये तो गलत बहस करेगा चक्कर yes
Lordship may take up the Lordship rate petition 2475 because on the basis of this direction passed in this OA Lordship, the other way was disposed of Lordship. Lordship, the matter really is that
yes
Lordship, a notification was issued Lordship for recruitment to the post of postal assistant and sorting assistant from the GDS, that is Gramin Dak Sebak. And written examination was held, also the data entry that was also held, Lordship. But subsequent to that, when the authority find out that there was indiscriminate number of vacancies was notified. So, and various malpractices was in the nature of that video recording has to be kept for the whole process, from the sorting out of the question paper, the opening of the sheets, and the in the halls, Lordship, that was not found. So we decided to cancel the selection process, and that was put to challenge, and that was allowed, directing to declare the result and appoint accordingly, Lordship. So Lordship may kindly come to a written statement,
just a
Lordship.
minute. And this examination was conducted when?
Lordship,
This was sometimes in 2020.
Lordship.
19, my lord, initially 19, my lord.
19.
19.
Written was held on
Computer test was held in 2020.
20.
Computer test was held in 2020.
9 to be
After 9
precise.
months, they have cancelled the examination. That too without approval of the ministry.
Right. Let us first know what is whether this order can pass the muster of that reasonableness. 2020, there was an order cancelling the examination and the
Okay.
result. Correct?
10, 12 to 2020.
And what happened? No new process was initiated.
No, Lordship. Thereafter, they approached the court.
Immediately thereafter, they approached the court.
Lordship.
And was there any stay?
Lordship.
So the posts have remained vacant.
No.
Up till 2026 January, you have not initiated any.
Lordship could not, because the judgment order was in their favor, Lordship.
And without.
Now let us see the impugned order.
Lordship. Page 95, Lordship.
Yes.
Start from page 104, Lordship.
One second. No, it starts from, I think, earlier pages.
104, Lordship.
No. It starts from page 100.
Start from page 91.
Recital part,
Recital
104, 104.
from 91, madam, in my record.
कोई दूसरा जजमेंट तो हम नहीं देख रहा है
Recital part.
120 का तो पेज ही नहीं
Noel Molina, Sanatan.
हाँ।
Santanu San-
70.
Okay. That's on page 104.
There may be lordship in this.
All right, yes.
The discussion starts from paragraph 12 onward. Okay.
Must vital para 18 your lords. 18 of the impingement.
1890.
18.
Different against wrong proposition of the one. So, nearly, at least put the quantum tested right. Yes,
My lord, lordship,
absolutely wrong proposition laid down by the tribunal. It, to our mind, see, the selection of the making of the select list does not give you a fundamental right to be appointed. It gives you a right to be considered only.
lordship may look into this. This has been done without approval of the Ministry of Communication. And communication have a Ministry of Communication, lordship may para 18.
Then
That-
that process was vitiated.
No, my lord, all over India, same examination was held. After 9 months of the examination, this has been, my lord, cancelled. This examination has been cancelled. When all over India, my lord, this examination has been over.
All over India, the advertisement would have been different. for
And
different
lordship may
circles,
look into the
no?
ministry's letter. Lordship may look into para 18 of the judgment, impute judgment. Para 18, my lord.
Right,
Para 18. Para 18, my lord. I'm reading it.
please.
Lordship got it. Para 18. And now Assistant Director has filed when the Ministry of Communication has rejected how Assistant Director of Staff can file a writ petition. My lord, in the present case, appropriate cancellation of the impugned selection process, the headquarters of the Postal Department by its letter dated 2/2/2021 had already observed as under. This is Ministry's version, my lord. If there was some mistake in calculation of vacancies, mistake is on the part of the respondent. The result should have been worked out as per revised vacancy.
That would be subject to a lot of litigation, can't be done.
No, this is, my lord, happened in Assam only. Assam only. As regards CCTV surveillance, even if there were instruction of directorate to ensure, but there should have been sound ground of cancellation, cancelling the entire exam process. There is no clarity whether any complaint was received as regards malpractices in exam and whether those were found genuine. Then, my lord, next page, your lordship will find, as regards, these are ministry saying, not ministry saying, my lord. As regard discrepancies in evaluation of OMR sheet, the same could have been rectified. There was no specific instruction for the work of setting without cancellation, and the ministry has come down heavily against the Chief Postmaster General. And my lord, last para, your lordship will find, in view of the above, competent authority has desired that a self-contained report on the aspect mentioned in a para 1 above may be intimated along with the reasons not to consulting with directorate before taking the decision of cancellation of examination.
We are not finding the decision of the ministry also to be correct in view of two facts: that the vacancy position was wrongly stated, the entire advertisement gets vitiated, and number two, if there were CCTV surveillance, that could not have been.
No, it says it is not a specific para 4, your lordship. There are no specific instruction. It says para 4 of the ministry's letter.
Mr. Chanda.
Para 4.
Mr. Chanda, tell me one thing.
My lord.
What right do you have?
My lord, because
Substantive right do you?
but without application.
Now you will be given another opportunity despite your having crossed that age.
My lord, I'm.
And that is what the department also, the railways also offered before the tribunal. The tribunal should have been slow in setting aside that decision. Now, there was no malefides on the part of the railway administration. It was not being done to help out somebody.
Not railway administration, postal.
Huh?
It is a postal department.
Whatever, postal.
No,
The
even before the tribunal, on different occasion, in the judgment itself, it is reflected. Different of the tribunal also mislead. On different occasion, different nature of vacancies were shown. At one point of time, it is 87. At one point of time, my lord, it is 62 by the affidavit. By the respondent itself. And now the assistant director.
They are to, Mr. Chanda, don't get excited. They are to be faulted with. They are the persons who came out with an advertisement without first working out the vacancy position. They were the persons who were responsible for the purity of the examination. They have failed.
There was no complaint at all, my lord. There was no complaint at all. There was no complaint at all, my lord. And on the basis of, and therefore ministry has come, and without, this writ petition has been filed in the name of Union of India by a assistant director of staff, whether it is maintainable. On behalf of the Union of India, when the Union of India has rejected their, my lord, the cancellation, and have came down heavily. Can assistant director?
This is an important ground which requires consideration. Now you have come up with a good ground now, midway of your argument. What authority do you have?
Lordship, only he has swear the affidavit, Lordship. An affidavit can be swear, Lordship, can
but
High Court rule. High Court rules. No, he has only swear the affidavit, Lordship.
No, we have
This is filed on behalf of
But
Indian.
why is the postal department blowing hot and cold in the same breath?
No, Lordship, who is
Just a minute. There is a substance here. So far as purity of examination is concerned, we are absolutely sure if the purity is diluted, we are not going to sustain that.
There is
Just
no
a minute.
complaint, my lord. There is no
Mr.
complaint at all.
Chanda, halfway through you came with an argument which has found favor with us. Now let me turn back. Now look at this, Mr.
Lordship.
Paragraph 18 again.
Lordship.
This is the view of the postal department.
Point number 3.
No, this is view of
Paragraph
postal
18.
department. We are not on the correctness of the decision of the postal department. Agreed.
Lordship is referring paragraph 18.
Therefore, when Mr. Chanda read it out, we were absolutely sure that this reasoning is incorrect.
Lordship,
Now, how could now the judgment, the order by the CAT in favor of the department be questioned by the department when it was their stand?
Lordship, this is an inter-office memo. Lordship. And
Let's see
Lordship, advertisement,
let us see the letter dated 2/2021. Where is that?
that is not part of.
Why?
I have placed it on affidavit in opposite. I placed it affidavit.
Where?
But-
Yeah.
Yeah.
Halfway through, you have come up with a good argument. This has turned the tables now for the purposes. Now, please show that letter.
That's letter your lordship will find 585 of
This-
my affidavit in opposition. And those materials they have suppressed.
1 second. This is by the Chief Postmaster General. No, to Chief Postmaster General by
Assistant Director
Assistant
General.
Director General. ये कुछ नहीं. And what did CPMG say? What decision was? CPMG can be said to be the government for the purposes of the department.
Lordship, here the notification was issued by
Chief
CPMG.
Postmaster General. What did he do after that? And what did he do thereafter? Where is the further communication from CPMG to the authorities?
That part is not clear, Lordship. In any case,
Just a
Lordship,
minute, just a minute. These were only instructions. And convey the following observations on your report. And where was the report?
so one inquiry, one
I'm
inquiry,
asking for something, Mr. Chakravarti, either you answer, or leave it.
one
to us.
inquiry is conducted, Lordship.
Thereafter, an inquiry was conducted.
It was not prior to that, Lordship. Prior to that,
No, what does it say? Look at the first paragraph of this letter. I am directed to refer to circle officer's letter number so and so dated 8/1/2021 and to convey the following observations on your report. Whose report?
perhaps this is the report, Lordship. I can take specific instruction, but one report is there prior to that, Lordship.
No, the report, we need a report
After that, after this letter, Lord.
after this letter.
Lordship, I will
No,
take
no,
specific.
not after this letter. Why can't you have some patience, Mr.
Lordship,
Chakravarti?
Lord.
Now, this is a letter being written to CPMG by the Assistant Director General talking about a circle officer's letter dated 8/1/2021 and the report of the CPMG. Where is that report?
8/1/21, I have that, Lordship.
8/1/21 is the letter of the circle officer.
That I have.
Show it.
This
This
is
is
a
the
report,
report.
prepared on the basis of a inquiry, Lordship. And this GDS to PA and SA, that part is, Lordship, I flag mark it, Lordship. The finding. paragraph 2.1.8 onwards.
Here, here, if there is no seat available, how can it be worked?
And at point number 4, Lordship will find that web asks for taking action against the hearing official also. At point number 4, Lordship.
And who is this? The authority which has written a letter at its Assistant Director General is above CPMG.
Above CPM.
Then what happened? Was the report of the Additional Director General accepted?
Whether this was a respondent or not, Lordship, for that I have to take specific instruction.
Therefore, when Mr. Chanda raises an issue with respect to maintainability, see, these are interdepartmental
Inter-office
memos.
memos, inter-office
We are for that.
correspondence.
But then the bigger authority, then the report making authority says that no, your report is bad, it's lopsided. Then a decision has to be taken by the government. How was the how this appeal is being filed?
Lordship is only that what point has been made, that's only in respect of swearing of affidavit, Lordship.
Now, Mr. Chanda, please refer to us the entire thing because he has raised an issue of maintainability at your end.
No, Lordship, Lordship, for that, let me take a specific instruction to that regard, Lordship.
My lord.
Because Lordship, before filing a writ petition, vetting has to be obtained from the highest authority, Lordship.
That is nothing. Those are mechanical, decision making. So many.
In any case, Lordship.
Registry puts up before me so many matters
No.
that whether an appeal should be filed before the Supreme Court. I say yes, let the matter.
Lordship, here the notification was issued by the Chief Postmaster General. He asked for cancellation. He is the appropriate authority to take decision,
What
Lordship.
happened after? The
After,
Additional Director General's report,
Lordship.
commentary on the report of the Chief Postmaster
For
General.
that, I'll take a specific instruction.
That's what we are looking for.
Let me take instruction to that. Lordship may fix the matter on Friday, Lordship. Or after vacation, Lordship.
Now, he therefore, Mr. Chanda would be right to that extent. He may not succeed ultimately.
Lordship.
We don't know. He may or he may not. But he says that the very decision of yours to cancel the examination was incorrect. It did not have the sanction of the authority.
Whether this letter of the director
And
is,
then it was only late in the then it was only late in the day that it dawned upon you that now it has been cancelled. Let it be cancelled. We'll see. Because otherwise, we are not what the Additional Director General has written.
whether he is also the appropriate authority or not.
Whether
Lordship.
he has written whether he has taken a correct view of the matter is something which we can question.
Lordship.
Because if there are no vacancies available, how could examination have been
Exactly.
held?
They have filed an affidavit, my lord, and 62 vacancies they have sold. They have formed a committee, and 62 vacancies they have on a question by the tribunal. They have filed an affidavit. Affidavit they have enclosed. 62 vacancies are there.
That's all right. The report says that due to reporting of abnormal vacancies by Kachar division and due to non-implementation of a pollution ordered by Directorate Circle Office, the ratio between the number of sanctioned posts and working strength in respect of PA cadre in Kachar division has almost become equal, and thus resulting in non-availability of posts for accommodating any more candidate in the Kachar division if the results are to be declared. So therefore, they would see this vis-a-vis their affidavit. This has to be accepted. No.
No, thereafter they have filed the affidavit. Affidavit date is different. During the course of
Anyway,
the.
you have to find out.
Yes,
You are-
that affidavit, Lordship, 579. 579, affidavit,
Yeah.
their affidavit. Their affidavit before the tribunal, saying 62 vacancies.
you have demonstrated it. Now, it is-
62 vacancies.
look at this.
Let me take a
This is an oath. There is another oath.
They have given, on the basis of that judgment was passed.
Therefore, his officers would be in soup if they do this. Then they're it's a complete ad hocism.
And that affidavit, they have not enclosed in the
Let's
writ
have
petition.
our-
They have not enclosed in the writ petition.
You get very excited, Mr. Chanda.
Sorry, madam. Sorry.
Because of this excited, argument, we have been forced to think all over again. That's good. No need to feel bad, but allow your arguments to sink inside the mind. I mean, if you keep on, hammering one point, the nail would go outside the wall.
Lordship, I will take
Mr.
specific,
Chakravarti, your officers would land themselves in trouble because of this.
Lordship, let me take specific instruction after this.
Then you
after
don't
this-
deserve to be, the examination recruiting authority. You are very casual about it.
No, Lordship, question may also come whether under what, whose direction the assistant director wrote this.
No.
That has the sanction of the,
Mr. Chanda may have been very excited in arguing, but he makes sense
Lordship.
in the sense
Lordship.
to the extent.
I will try to
Just a minute.
clarify.
Once you say that no post would be available, and then you file affidavit much later that 62 posts are
No,
available.
Lordship, that was in respect of Kachar division only.
So
No, no,
for
all over
others.
Assam. Not
No,
Kachar division.
Lordship,
All
the
over Assam.
report says
Anyway, you find out and tell us, and don't come out with, don't give us something, some report, ad-libbing a report. No, please.
Lord.
In that case, if we find that your decision, even otherwise, suppose we find that. And what business you had if you were really sort of serious about cancelling the exam, you would have gone to the CAT for vacating this stay, because these posts are empty. These posts remained vacant for about 5 years.
Lordship will take this, perhaps MA was filed, Lordship. second.
Perhaps is
Lord,
not
let me
something
take-
what we accept. What was your effort? What did
Lordship.
you do? That means you don't require any further personnel.
In my lord status report, one set of vacancy shown. In detailed statement, one set of vacancy shown. In affidavit filed subsequently on a query by the tribunal, they are separate set of vacancies shown. And these people burning the candle throughout the night, they appeared in the examination. And 2019 examination.
That is not moving us. That is not in our minds. Your difficulty is not in our mind. We are looking at the purity of the examination and the correctness of the decision to cancel the examination.
And there was no complaint at all, my lord.
That is irrelevant. Suppose there is no complaint, everybody is in cahoots with each other. But if the authority which has conducted the examination finds of its own that, look, this is bad, it's no test of merit, everything has gone wrong, that's no argument. Plus, merely because a select list has been prepared, you can't come up before us. This is because they have decided, the top authority said that no, there was no need of cancellation. Still, the department went ahead and cancelled the examination result. And then if the examination result was cancelled and the matter went before CAT, CAT may have done that, but why should he file an appeal? Why should he file a writ petition? That is what we are looking at. This is what has struck our, mind. Otherwise, the view of this court is that if there is some problem somewhere in the examination, and if it pervades the entire system of examination and selection, then everything has to go. This is the view which we hold. And it is not very off the line. It is not absolutely out of the perpendicular. This is the national view.
And that is the view, my lord, in the East Coast Railway, what your lordship is saying, that when you cancel the examination with due application of mind, what your lordship is saying came in the judgment of the Supreme Court.
All right.
When closed it.
You tell us.
Supreme Court also says same.
Mr. Chakravarti, learned CGCA. You write CGCA, Central Government?
Council.
CGSC, learned Central Government Standing Council, seek some more time to take instructions of the matter before finally addressing this court. Re-notify. Why did you not, we need to know your conduct also. Did you file any application for cancellation, for vacating the stay order?
Lordship, I will take instruction to that regard.
Otherwise, we'll say that you are happy. All right, take instructions.
Deeply.
Mr. Chanda, remind us on that date. We are not recording anything. Remind us that this was the issue.
Obliged.
3rd February.
Obliged.
Supplementary list. Supplementary list, item 52.
ये खत्म हो गया इसका? Item 50? नहीं देखा, क्या है ये?
May it please, your lordship.
Yes.
The transfer order is in question here, my lord.
Transfer order.
My lord, the member cat trespassed an order which is against us.
Can we see the order?
Yes, lord. I'll take your lordships at page 476, my lord. Your lordship may come to page.
Give us 2 minutes, Mr. Datta.
Yes.
इसको चेंज करो जिसका फूड वाला मंगवाओ क्या लिखा बाइट फ्रॉम द मार्केट बिल इट ऑन मी ओके आई एम यूजिंग इट बिल इट ऑन मी forget about high court expenses this comes here Yes, Mr. Datta, the very fact that you are there for 14 years, the reasons that you have accorded, that you have suggested, your wife is working and your mother is ill, that's true for everybody. 99% of the people. I don't think.
My lord, I'll just take your lordship two small points, my lord. The first, my lord, your lordship. may
Apart
kindly-
from Abbas's case, there is another case where which puts us in complete, behind the picket line. We can't cross that.
No, that, my lord.
KL Abbas, and there is one case from Patna. On that.
So for the transfer case is concerned, my lord, we are all aware of what is the position of law. But nonetheless, my lord, here is a case, if I can take your lordship to page 127.
Just a second. I just remembered one judgment which I had always been using.
বললো বাহানে आउट ऑफ घूम रहे हैं
KL Abbas and the other one. Anyway, yes,
my lord, if I take your lordship to page 127,
what is that?
it's my lord, the transfer policy clause 4 point small I,
125,
127.
3 years tenure, you're sure?
I'll just try to persuade your lordship. You know, exemption from transfer.
Now I remember the case.
Yes.
Shilpi Bose versus State of Bihar.
Will be both, yes. Now, your lordship may kindly see here. In case, as your lordship got there, page 127.
Yes.
Exemption from transfer, deferment of transfer. In the following circumstances, exemption from transfer or deferment of
The
transfer
first line may be considered.
may be considered. Now, my lord, the further, my lord, in case where officer or his her family member is suffering from serious ailments such as cancer, polio, mental, psychiatric. Here, my lord, my mother is a psychiatric patient. Paralysis, etc. Or, your lordship will find the word or is added, is a disjuncting order, I mean a word. So therefore, my lord, or is PWBD. Now, this is, my lord, this is the difference here. If I am suffering from his psychiatric disorder, my lord, possibly I am not required to say what percentage of disability I am suffering. Now, there are cases that, my lord, I will have to show a certificate that I am disabled by 40%. Now, in case of a cancer patient or, my lord, polio or mental disorder, I don't think there is any precise measure to, my lord, determine the disability of the patient. Nonetheless, my lord, if your lordship feel that taking into consideration, reading down the provision of law to give the real intent of the legislature, that's a different issue, my lord, where war can be shown as at end. Now, whether that sort of analogy can be brought here.
The reasoning of the tribunal is that you are not 56 years of age, right?
Yes,
So the transfer policy would not be applicable so far as you are concerned.
my lord. My lord, there I'll say there is a tainted with malafide in the sense, my lord, if I take your lordships to page 131.
We are not getting persuaded.
No, my
For
lord,
the
I can
reason that
understand.
out of 29 years, you spent 14 years in Zorat.
My lord,
Such senior division, you can't.
now can
Even if it were, we would not have interfered.
my lord, can I take your lordship page 131? My lord?
Yes.
My lord, these are the 2 points I'll argue. I'll not take your lordship's valuable time. My lord, page 131, para 14. Tenure of independent officers and IFA officers. Your lordship will find.
Everything, recedes into background on the plea of administrative convenience.
Yes, that's true, my lord. That's true. Your lordship is.
That's what Abbas says. And where are the Malafites?
That has been indicated here also.
No breach of a statutory rule.
That's
These are
approved, my
made.
lord.
You are aware. Why do we tell you all this?
But one thing your lordship can see here, it is said that in the IFA offices, the minimum tenure is 3 years. Now, in my case, what happened? I worked there for 1 year and 4 months only. And they have transferred me. The reason is that,
Have you joined the other post?
oh, no, not yet, my lord.
You're on leave.
Lord,
This order must have been passed long time back.
your lordship is correct, but the counsel who is assisting me, he's out of station, my lord. I cannot say whether,
No. But if you're on leave, then we'll take a very serious view of the matter.
my lord, I understand that, my lord. Now,
Then
now
we don't
here,
even,
here
on
what
this
happened.
ground, we'll say that at such a senior level, you have deserted. Then it will call for another action against you, not only transfer and effecting the transfer.
That your lordship, what your lordship is thinking, the appeals court has, my lord, already settled that position. It may amount to misconduct also.
That is misconduct. And then it disentitles you to press this petition out.
But then your lordship kindly see, a good governance.
Please tell us
includes-
what is the status? Has he joined or has he? What was the order?
Possibly, my lord,
The order of transfer is dated?
16/4 to, just a minute. 16/10/2024.
2 years.
Uh,
1 year.
1 year, few months.
1 year and 3 months. No stay, nothing.
Earlier it was in the,
So when was the stay vacated?
before the cat. My lord, when the judgment was passed, after that, my lord, there was
So
no
the
talk.
judgment will count it from that day.
It was passed way back on 26/9/2025.
Then it's not so.
It's not,
in
not that,
past.
my lord.
But then somebody else would have been posted in your place. Have you relinquished the charge?
That
Have you
also,
given the charge to him?
yes, promotion.
Now you're creating problems for others. Mr. Datta, you're
My
creating
lord,
problems.
only thing what I wanted to persuade your lordship, in the post minimum in that particular office is required to work for 3 months. Your lordship may ask that whether is a guidelines only, it's not an, my lord, all that question I'll have to face. But then if your lordship
See,
consider that,
everybody's parents grow old. They fall ill.
yes, yes.
In today's world, every spouse is working. Can that be a ground to remain, fixated at one place?
No, no, one thing your lordship
Then
kindly see,
we'll have good ground for.
a sympathetic consideration, sympathetic concern, sometimes it calls for, because the mother is 81 years of age and she has been suffering.
There are people whose mother is 85 years old, wife is working. I mean, can they claim that they should be posted where the wife is working? I mean, that's something very unusual. And that also at such a senior position.
That's true.
What do? We dismiss it?
My lord,
But we will record something that you will direct that you must hand over the charge and join the new place of posting. You want that?
my lord, I leave everything up to your lord. So
We see many a times you don't like to do something, especially in view of the good arguments that was polite argument that was. You don't want to travel. We'll just dismiss it. We have heard Mr. So-and-so, Mr. Datta Land, senior advocate for the petitioner, and so-and-so for the respondent state. For the respondent? For the respondent / Union of India. The petitioner has questioned the order of the cat dated so-and-so, whereby the tribunal has refused to interfere with the order of transfer. Order of his transfer. Next, the petitioner has been transferred and posted from the office of Senior Deputy IFA (AF) Senior Deputy Integrated Financial Advisor, headquarters 10 wing (AF) of Razia, Jorhat, to the office of PCDA (pensions), Prayagraj, Uttar Pradesh. He questioned the aforementioned decision to transfer him on several grounds, but primarily for the reason of his wife working at Jorhat and his mother being ill, and he and the illness of a mother, and he being the sole caregiver. The other reason for questioning the transfer was that he had not completed the tenure of 3 years posting on the post from where he was transferred, which was against the transfer policy. He claimed exemption from transfer. He claimed exemption from routine transfer in terms of OM dated 8/10/2018, read with the transfer policy dated 31/1/2024. The stand of the Union of India is that there are no malefites in his transfer. Stop. A transfer order need not be interfered with, as it is for rendering prompt and efficient service, especially in defense forces. The transfers are imperative for aligning with the requirement at various positions with the user requirement, necessitating transfers to different stations. The records reveal that though the mother of the petitioner is stated to be ill, but she suffers from general anxiety disorder which may not bring her within the parameters of benchmark disability as per the Right of Persons with Disabilities Act 2016. The ground of spouse working at a particular place is no ground to stall or effect transfer. So that apart, on finding that out of 29 years of service, the petitioner has spent more than 14 years at Jorhat, we are absolutely uninclined. We are absolutely disinclined, not uninclined. We are absolutely disinclined to interfere with the order passed by the tribunal in refusing to question the transfer of the petitioner from Jorhat to Prayagraj. While saying so, we have also taken into account the judgment of the Supreme Court in Union of India versus S.L. Abbas, 1993 for SCC 357, reflecting, observing that only conditions, observing that no interference ought to be made against a valid order of transfer if there are no malefites or there is no indication of any infraction of statutory provision. We have also taken into account the reasoning of the tribunal that the transfer policy with respect to SAOs of the department is not applicable in the case of the petitioner, as he had not attained the age of 56 years when the order of transfer was passed. We do not find any anomaly. We do not find any good reason to interfere with the order of the tribunal. The writ petition is thus dismissed with a direction. Do we leave it at that, or
It's
we
better
say
to leave it that.
writ
Much
petition
obliged.
is discussed? एक शिल्पी बोस भी लिखना and शिल्पी बोस versus Union of India. सिर्फ वैसे स्टेट ऑफ बिहार citation ले लेना, उसी में कहीं होगा.
1991 2 SCC
Yes.
659. 1991 2 SCC 659. Supplement. Item 53.
May I please your lordship?
Yes.
My lord, this writ appeal is, my lord, directed against the impugned judgment passed by the learned single judge, my lord. Annexure 31 at page 251.
बहुत लंबा चौड़ा है. बाद में देखते हैं कब.
The person who does not possess the requisite qualification
Once,
as
once,
per the
once.
my lord.
एक पैराग्राफ. एक सेकंड. वो पैराग्राफ 12 थे. This is by Dr. Naman Rai. Dr. Anamya Rai. इसको पता नहीं क्या कहता हूँ. इसका जजमेंट 2/11/2024 order. Let's see the order dated 2/11/2024.
My lord.
2/11/2024.
Yes,
We
that
get it
is-
at what page number?
my lord. 190, my lord.
Huh?
190.
190.
That is the order, my lord. With all respect, my lord, it's a very cryptic order.
Cryptic
Not-
order, no?
My lord,
And though they
my lord, it's
say
not,
that it's a speaking order, page 1.
with all respect, my lord, it is not a, my lord,
Let us see first.
speaking order, yes. My lord, this honorable court directed to pass an speaking order, my lord. Page 190.
एक सेकंड. हाँ. Net conducted by UC who have a PhD degree in accordance with the University Grant Commission. But PhD in the subject. No. This was for which post?
My lord, assistant professor, Bengali department.
Bengali department.
Correct. My lord.
And you had PhD in
Bengali department.
your PhD subject?
My lord, subject, my lord, it is, I have annexed the, it
Can
is
you
from,
not tell us?
it is from Bengali department. My lord. As per the certificate issued by my lord, the UGC.
No, where, then why do they say that it is not in the concerned subject?
That is what, my lord, the, my lord, perversity. That is where the
Where has
perversity.
the single judge taken into account this argument of yours?
My lord, I have annexed, my lord,
Up is Mr. Sen. Mr. Sen, we are asking you a specific question, you answer
my lord.
specifically.
Yes.
Where has this been taken into account?
Paragraph 24 of the judgment, my lord.
Paragraph 24. No, where is that ground?
My lord, in our affidavit in reply, filed before the, my lord,
No, two
from,
subject experts, one head of the Department of Bengali,
my lord,
they found that your PhD degree is not on the concerned subject.
yes,
Why? How is it? Let us see your PhD degree. What is that?
yes, my PhD degree is at, my lord,
But how do we say so that the subject expert is wrong?
because, my
Your
lord,
PhD degree is where?
PhD degree is, my lord, at page 42, my lord. PhD degree the good. Page 44, my lord. My lord, the expert
No,
only
you're-
goes, my lord, with the title but not the contents of the thesis, my lord, that
No,
has
no,
been
no,
filed
no,
by
no.
the petitioner.
No,
appellant, my
sir.
lord. My lord,
No, sir.
my lord,
Your title of thesis is very, very clear.
my lord.
It is Cuisine of Sylhet.
No, my
What
lord.
has got this to
No,
do
my
with
lord.
Bengal?
My lord, lordship kindly see, my lord. Center for Interdisciplinary Studies. My lord, it is the socio-culture study of Borak
आप
Valley
जरा
of
सा-
Assam.
आप जरा से इधर आइए ना.
My lord. So,
Just a minute.
my lord.
Page 42. This is the page that you have asked us to come to.
Page 42, correct. My lord.
Then this is the notification.
My lord.
Right?
Cultural studies.
Notification dated 23/2/2022.
Correct.
The department is Department of Cultural Studies, Center for Interdisciplinary Studies.
Correct.
Next column.
My lord.
Title of the thesis.
My
I
lord.
have not said something of my own, no?
Lordship is absolutely correct, my lord. There is no doubt
Read
about
that,
it. Your
sir.
lordship kindly see, my lord, title, my lord, this title has been defined by the UGC. My lord, your lordship, in our affidavit
you are talking of your entitlement for exemption of the basic qualification.
not exemption, my lord. I am from the Bengali department, my lord. That is,
Mr. Sen, if you don't understand the observations of the court, then I can't interact with you.
my lord.
The exemption from having a net or BET degree, net or CSIR degree, you don't have a net degree.
I have subsequent, my lord.
Subsequent means nothing. Subsequently, you could be delete, DSC, whatever. At the time of interview.
After interview, yes. After interview, I got the degree
Mr.
of.
Sen, argue on the point.
My lord.
Right. You did not, when you were interviewed, this was not the minimum qualification is NET or CSIR.
My lord.
You did not have that.
At that point of time.
At
no.
that point, you did not have that.
Correct.
Therefore, you wanted it to be exempted so far as you are concerned because you are a PhD.
Correct.
Correct. So PhD should be in the subject.
Correct.
And subject is cuisine.
No,
Not
my lord.
bang-
Subject
not-
is socio-culture, my lord. Socio-culture of the Barak Valley, my lord, with all respect.
Mr. Sen,
Independent.
please don't take it otherwise.
Why not?
We are very much interested in your thesis. It is a wonderful topic. Now, different cuisines of Sylhet.
No, my lord. It is, my lord, your lordship kindly see, my lord, chapter 2 and chapter 4 of the thesis. I have submitted the thesis. It says, my lord, the contents of the thesis, my lord. It says how
You would
the
be teaching.
Bengali language has been evolved, my lord. That is what the
That's
thesis
different.
is, my
That's
lord.
different. You know, in the Institute for in the Institute for Buddhist Studies, can you take the plea that somebody from Bihar who says that the Buddhist language Pali developed in the state of Bihar, and the present day cuisine is present day Bihari cuisine is an offshoot of Buddhist cuisine, and therefore he would know everything about Pali.
No, my lord, that is not the case here, my lord, exactly. My lord,
Exactly,
with
that
all
is the
respect,
case.
with all respect, my lord. Your lordship kindly see, my lord, page 245 of writ appeal, my lord. Page 245. It was filed as, my lord, affidavit in reply before the learned single judgment. And that has not been considered, my lord, appreciated by the
245.
245, my lord. 245 is the, my lord, certificate issued by the, my lord, Sodh Ganga. Sodh Ganga is a, my lord, online library issued by the University Grant Commission, my lord.
नहीं नहीं, कुछ नहीं है. Cuisine of Sylhet, a social cultural study on Barak Valley of Assam. देखिए ना पेज 40. यशोद गंगा बहुत प्राइवेट बॉडी है जो
No, my lord, 245 says, my lord, the name of the department Bengali.
department is all right.
So here, my lord,
your department is cultural studies.
no, my lord, with all respect, my lord, the department here, my lord, this Sodh Ganga, my lord, this is a digital laboratory, my lord.
In that case, in case of such confusion, we will go by what the experts say.
My
Two
lord,
subject
your lord,
experts, two subject experts, one being the head of the Department of Bengali literature, he says that no, this is not our subject.
my lord,
How will you get exemption? Now, if you don't get exemption, you're not qualified.
that is, my lord, subject, my
And
lord.
why did it take the learned single judge so many paragraphs to decide that you don't have the qualification?
Because, my lord, we have, my lord, challenged the, my lord, requisite qualification of the respondent number 8, my lord, who has
That
been
you cannot.
selected. And,
That
my
you
lord,
cannot, Mr. Sen, can you question that you have better brains than the judges, therefore they can't decide?
No, my lord, that is not the case here, my lord. My lord, what I am submitting is that
Can you
my
say-
PhD
can you
is
say
in
that-
Bengali
Can you
language.
say that when the judges are not as educated as the advocate and therefore they cannot decide my case?
No, my lord, with all respect, that is
The
not.
subject expert.
No, my lord. My lord, expert opinion. My lord, 2014, my lord.
Where have you questioned that? Have you questioned that?
Yes.
That he was not capable enough of deciding. whether
Yes, my lord, that is absolutely our case.
No.
That has been ignored in paragraph, my lord, your
No, it
lordship.
has not been ignored. It has
Yes,
been
my lord.
answered.
Paragraph number 14, 15, 17, 18, 20, 21, 23, 27, 33, 35, 37, 38, 39, 40 of the writ petition. And, my lord, the prayer portion A of the writ petition, my lord. Our entire case is that the selection and the expert committee opinion is, my lord, not in accordance with the guideline, and, my lord, the advertisement that has been published in terms of the for appointment to the post. My lord. This part of the, my lord, pleadings has not been appreciated by the learned single judge.
Who appears for respondent number 8?
Respondent number
We have
8.
not
my lord.
issued notice.
Respondent number 8 did not come, my lord, despite its service of notice, my lord. Before the.
You are appearing for whom?
Correspondent 1 into government.
What do you have to say?
It's clear that the subject was not in concern, PhD was not in concern subject. Honorable Court has passed the detailed order, Lordship, considering that only.
No, my lord, honorable court, my lord, they cited the judgment. of
Page,
that
page,
is,
Forget about judgment.
page
my lord,
274.
we have two judgments, my lord, by the Supreme Court, my lord. Honorable Supreme Court says, my lord, expert committee view is a subject of the judicial review, my lord. My lord, it can be questioned, my lord. It is not a case, my lord. Generally, the expert view is respected, my lord. But, my lord, Supreme Court says it is not in all circumstances, my lord. Paragraph 14, my lord. Paragraph 14, my lord. And this case is, my lord, absolutely is a covered case, my lord, identical case in hand, my lord. My lord,
Ganga.
here, my lord, says when two views are possible, expert body has taken a possible view, the same deserves acceptance. However, it does not mean that expert body's opinion deserves acceptance in all circumstances and is not subject of judicial review. My lord, paragraph 14 and paragraph 23, my lord, it is, my lord, categorically stated that it is a subject of judicial review, my lord. Even if, my lord, there is an expert view, my lord, that expert view, with all respect, my lord, can be a subject of judicial review, my lord.
पर ये अपने है तो हम इसमें बड़ी
My lord,
sorry.
contents of thesis, my lord, are absolutely for evolution of how, my lord, the Bengali language has evolved. My lord, we are on, my lord, your lordship kindly
We are only amused. If I had known Bangla language, I would have certainly read your thesis. How can food lead to evolution of language?
my lord, but the expert committee, my lord, did not consider or appreciate the contents of the, my lord, the thesis that has been submitted. Only when to the, my lord, title of the.
Somebody must tell that young advocate who is sitting on the back, his torch is on and it's almost blinding us there.
Mobile
Sorry.
My lord, your lordship, my lord, my lord, your lordship may kindly, my lord, call for a report from the University
No,
Grant Commission.
Not at all.
My lord, whether the PhD degree of the petitioner.
We are not even inclined to issue notice to respond number 8.
My lord, page 245, your lordship, I have shown, my lord, that it is in the Department of Bengali. Page 245, my lord, Shodh Ganga, it is their certificate, my lord, issued by the UGC. University Grant Commission, my lord, says that that the PhD degree is in the Department of Bengali, but there, my lord, the expert committee is saying that it is not in concerned subject. That means it is not in Bengali language.
नहीं जो चार्ट दिया था Amen. We have-
My lord, respondent number 8 does not have the PRC, which is one of the
Second division in matriculation, everything.
all
right.
along third division does
Aapka
not
kya
have
hai?
my lord,
We are get-
55%, which is
We are
mandatory.
looking at your case, not of
No,
respondent.
correct, my lord, correct. I have to stand my own footing, my lord. Your lordship is correct. But with all respect, my lord, my thesis
No,
and
you're-
my PhD degree,
Where
my
is
lord,
that, which is that page?
my lord. Page 245, kindly,
245 I've seen Shodh Ganga.
my lord.
We are asking for another page where there was a chart, the date dated so and so. Which you showed in the first instance. Which you showed in the first instance. From where did I know that it was Sylhet, Barak Valley food?
My lord, page 246,
PhD notification. Show us your PhD notification.
page 42, yes.
Page?
42, my lord.
Page 42. Yes. This is your notification. Why do we go to Shodh Ganga, which is a private,
No,
peer
it's not
assessment?
private, my lord. Page 246 is not private, my lord.
Page 246 is not
246.
private.
No, my lord, it's not private. There is a, my lord, MOU in between infill bid and UGC, my lord. It is conducted by the UGC, my lord, University Grant Commission, my lord, with all respect.
Anyway, but we
My
are
lord,
more,
it is, it
we
is
are more
maintained,
concerned with
page 246, lordship, kindly see, my lord.
that we have seen.
It is maintained by infill bid
all
center,
right.
which is
So,
then
but we are
autonomous,
concerned- This is the university
my lord.
which is coming out with a notification. Along with you, there was another Rakesh Kumar Bez Barua. His was in Assamese. Yours is in Cultural Studies Center for Interdisciplinary Studies. So Shodh, whatever Shodh Ganga or whichever body is there,
My lord.
we look at this notification. Do we need to go any further? This notification is good enough.
My lord, it says regarding the title, my lord. But ultimately, my lord, the thesis and all, my lord, your lordship kindly appreciate, my lord. The thesis that have been submitted, the research that has been done by the appellant petitioner, my lord. It is on the Bengali subject, my lord.
Folklore, your contents of the thesis are Sylhet and the land of the people, folklore of cuisines, cuisine of Sylhet.
There is one of the chapter, my lord. There are altogether 6 chapters.
I'm reading out chapter wise.
Yes,
Discussions and conclusions.
Chapter,
Nothing about Bangla language.
my lord, chapter 2 may kindly be seen, my lord.
Sylhet and land of people, and Sylhet, the land and people. Sorry, sir, they are unnecessary.
My lord, your lordship kindly see, my lord, page 92, chapter 2 of our
92. Yes.
page 92, before partition, Assam witnesses to see huge number of Sylheti group, but later it changed conflicting in East Bengali language. Both are Bangla, but both are not same. There is always seen a comparison between Sylheti and Standard Bengal. Now, my lord, thereafter, my lord, though the page 93, though local language was Sylheti, it was still not matching with the Standard Bangla, which is in practice in the Bengal region of India. Bangladesh people then finally decided to skip Sylheti dialect. Then your lordship may come at the bottom, my lord. But the problem regarding the preservation of the language is that all the Sylhets residing in the Barak Valley are not much conscious about their language history nowadays. Due to cosmopolitan city in Barak Valley is also become a media express their own thought rather using their own language refugees become a impactful term on this community. These always felt themselves
Qualification for yeah. कौन से नाम क्या है ये वो कौन है
people can easily be recognized in Karimganj, Assam, as he or she is Sylhet because they have captured their own culture with authenticity
Right
and
now.
preserved.
They have heard Mr. B.K. Sen, learned advocate for the Palan, and Mr. A.R. Tabildar, Standing Council Higher Education. The petitioner has questioned the judgment dated so-and-so, passed by a learned single judge of this court. In so-and-so, whereby no interference has been made with the appointment of respondent number 8 as lecturer in the Department of Bengali language in Pandit Deen Dayal Upadhyay Adarsh Mahavidyalaya at Irali Gul, Sri Bhumi. It appears that the principal of the college had issued an advertisement on 27/2023, 27th month, 27/2023, for appointment on the post of assistant professor of Bengali language. Pursuant to the advertisement, the petitioner and others, including respondent number 8, had applied. The petitioner had appeared in the interview on 29/8/2023. But her candidature was not considered on the ground that she did not have the requisite qualification for being appointed as a lecturer in the Bengali language department, as she did not have a neat, as she did not kitna page tha paragraph? As she did not have the NEET certificate. She did not have, as she did not have NEET/SLET/SET certificate, which is one of the which was one of the mandatory requirements of eligibility. The petitioner claimed that she had a PhD degree and therefore her candidature would be had to be exempted from the requirement of NET/SLET/SET. The experts, after a protracted litigation, found that the PhD degree of the petitioner of the हम कहाँ petitioner लिखे हैं वहाँ appellant करना of the appellant was not in the concerned subject of Bengali literature, but it related to, but it was obtained under the Department of Cultural Studies, bracket Center for Interdisciplinary Studies, and the thesis topic of the appellant was, within quotes, Cuisine of Sylhet, a socio-cultural study on Barak Valley of Assam. Nonetheless, the appellant persisted that the title of the thesis of title of a thesis was about cuisines, but in fact, the contents were replete with research on the evolution of Bengali language. Full stop. In the first instance, a bench of this court had directed the departmental authorities to look into the matter and pass a speaking order. Full stop. Pursuant to such a direction, a speaking order also was passed on the contentions of the appellant, which also has been challenged in the present appeal, which also was challenged before the learned single judge. The candidature of the appellant was not accepted for consideration for lack of essential qualification, essential eligibility qualification. The learned single judge, on finding that the appellant did not have a NET/SLET/SET certificate at the time of interview, and that her PhD was not in the subject, which was certified by two subject experts, which fact was certified by two subject experts, refused to interfere with the decision making of the authorities in rejecting the claim of the appellant. The appellant had also questioned the appointment of respondent number 8 on the post of lecturer, on the ground that respondent number 8 is he or she. She did not have a good academic record, and therefore she should not have been appointed. For the present,
And also, my lord, sorry to interrupt. And also, my lord, the PRC, permanent resident certificate, which is also mandatory in terms of advertisement,
the respondent number
as
8
well as, my lord,
was also stated.
he was
Well,
not
the
having
respondent number-
NOC.
the candidature of respondent number 8 was also stated to have had many other anomalies, which actually disentitled her for consideration. For the present, we have examined the eligibility qualification and the PhD thesis of the appellant, and are of the considered view that the appellant lacked the eligibility qualification for being considered. At the time of interview, she did not have the requisite NET/SLET/SET certification, which could have been exempted if she had a PhD degree in the concerned subject. The opinion of the experts that the PhD thesis of the appellant was not in the concerned subject has to be given precedence to the tall claim of the appellant that though the thesis talked about culinary specifics in the Sylhet region, but the thesis dealt with the evolution of Bengali language. Out of curiosity, we also cursorily went through the content profile of the thesis and find that it was, and have found that, and we found that it was primarily with respect to the evolution of culinary habits, the culinary habits and the food prevalent in the Sylhet region, especially with reference to Barak Valley in the state of Assam. Thus, finding that the appellant did not have the requisite qualification at the time of interview, we do not think it appropriate to interfere with the judgment of the learned single judge. The appeal has no merits.
My lord,
Dismissed.
we have cited one judgment that may kindly be reflected, my lord. Yes. But I have given it, my lord. 2014 3 SCC
The learned Mr.
767.
Sen,
That expert committee view is a subject of judicial
The-
review.
will deal with it. Mr. Sen, because it is highly relevant, therefore we chose to ignore it. Nonetheless, Mr. Sen, ऊपर उसके बाद लिखना before I get Mr. Sen, learned advocate, has also cited a judgment of Supreme Court, namely Ganpat Singh Gangaram Singh Rajput versus Gulbarga University, bracket 2014 3 SCC 767. In support of his contention that the assessment of the subject expert regarding the thesis is not to be taken as sacrosanct, and that it is subject to judicial review. There can be no quarrel with that proposition. But in the present case, it is absolutely clear that the appellant did not have the PhD degree in the concerned subject, namely Bengali literature, Bengali language, which is self-evident from the thesis topic and the content profile, about which we have already referred to earlier in the judgment. उसके बाद वही है.
Obliged.
Item 54.
Please, my lord.
Yes.
My lord, I'm not objecting to the right of the respondent bank to take the physical possession of the secured asset under section 14 of the SARFACI Act.
This is not the forum.
But at the same time, I say, my lord, with a lot of humility, that the manner in which the same has been done requires the supervision of the court, which will be in violation. I will come to that, my lord. The fact that how today I'll be remediless in case my
remediless.
I will be in my earnest submission. If I may be permitted.
No, it's a
to give a brief.
For your satisfaction, we can hear you at length, but then it is not required.
I will only take 5 minutes. Yes. So, my lord, what really has happened is that this land parcel is situated in the heart of the city in GS Road. The valuation, it is about 3 bighas of land, housing 5 commercial establishments.
That's all right. Let's come to the issue first.
Yes, issue. The issue is that on the face of it, there is arbitrariness, which I say in my most respectful submission, because this
Is it not debatable before the DRT?
No, my lord, it
Why?
will not be.
Why?
Because the issue of non-demarcation of the subject property is outside the purview of the learned
Says
judge.
so? Who has told you this?
Yes, my lord may kindly see at 160. In order to get a proper understanding of this order at 160, I will seek the liberty to just give a small brief about the land. Then this particular order will have relevance, if I may.
He has taken loan from so many banks.
Three banks, three financial institutions.
And you have been able to obtain orders with respect to action taken by the other banks.
So, my
Go
lord,
for the,
there are three financial institutions with who I had hypothecated the land, but the only issue is the non-demarcation of the property, prompting me to go before the civil court and file a suit for demarcation and partition, which is since pending. Today, the difficulty is that at page 160, if my lord has it, this is.
1 second.
Yes.
Yes.
At page 160, my lord, there is a stay on the confirmation of the sale, the auction sale, which has now been conducted on 22nd. But the sale certificate is right now on hold. In the meantime, what has happened on 23rd, they provide us with a vacation notice by virtue of this order of the learned DM dated 1st of December. 23rd December also happens to be the last working day of this honorable court. And before the reopening on 5th, on 3rd, my possession is taken away. Now, why I'm bringing that particular aspect into the foray is because, my lord, there is already an order of the learned DRT at page 160 where there is a stay on the confirmation of the sale. There's a stay on the confirmation of sale. So as such, the sale is yet to be confirmed. Now, the problem that has surfaced is this particular stay was granted by learned DRT on the basis that there is non-demarcation of the property. So under such circumstances, this particular possession that has been secured after having filed this petition, interestingly, we did the e-filing on Saturday. After 2 hours, my lord, after the service was initiated, this particular possession was forcibly taken. A property of 3 bighas, 2 bighas now stands already taken. Out of 5 establishments, 3 establishments have been abruptly shut down. My lord, all of this requires supervision because in my respectful submission, this will be in violation of my fundamental rights under 19(1)(g) and Article 21.
You're Mr. Das.
Yes.
Mr. Das, you have been contesting these matters. You're aware of the law position. Why are you unnecessarily asking for?
Please, I will just be precise then in that case, my lord, for your
Why
lordship.
are you asking for something which possibly you will never get from? And this is no code of equity here, especially in these matters.
I will
You
just
should
put-
understand the
please.
law, and you know it fully well. You're representing all, I mean, before so many, financial institutions,
forums.
Forums, you're there. Aren't you aware of the law?
My lord,
Why are you asking us to do something if you take us to be complete greenhorns in the subject? Good enough. You keep arguing.
my lord,
Mr. Das,
Just
if
one
you, do you think us to be greenhorns?
not at all.
And then
I will not dare to.
we will use our 226 jurisdiction for supervising all this.
My lord, just one particular aspect.
Sorry. Mr. Das, there is a limit to our patience also. No, we can't keep on hearing you unnecessarily. No, we have plenty of time. Not that we are short of time. We want to hear you. You're making good submissions. But then you know the law. Why are you pushing it ahead?
My lord, just one
Please, but
aspect. Okay, I will not pursue it. I will not pursue it. Just one aspect.
You want to be saddled with further cost from this court. Unnecessarily, we have heard you.
But I'll not dare that.
Every matter, you see the chart, you're aware of the situation because come to page 168. This is chart with respect to everything. Now, see, there are different, disputes intersee the agencies which have loaned you money. the civil court will decide. Are we to take charge of all such matters and decide the matters here?
Not at all.
Then,
Just one aspect I
it
wanted
not-
to bring,
is
just
it-
one aspect,
is
one single aspect.
Mr. Das, is it not a misadventure for you to have filed this petition?
In my most respectful submission,
No.
just one aspect, one aspect. My lord will permit me a minute. The issue of non-demarcation is an issue that is outside the purview of surfacing, which I cannot assert before the learned BRT, my lord. Now, the issue of,
Before the civil court.
yes, precisely, my lord, precisely. I'm so obliged. I'm so obliged. My issue now, on 9th of January, I have, my lord,
We are of the view that your client should be imposed with a cost.
I was just coming to that particular point, which my lords had just raised, that I should go and try my luck under 39(1) and 2 before the
That's something different. It's
Before
not a
the-
game of dice.
before the civil court. Now I say,
Game of dice. You produce evidence, you speak out your case, then get an order. Don't try your luck there. It's not always by luck that you succeed or you lose. Mr. Das, we are inclined to impose cost. It's a misadventure.
in that case, I'll take my chances with.
Especially, Mr. Das, when you are aware of all this, if you may be considering us to be greenhorns, we don't consider you to be.
I will not dare that. The only reason I had come is because of that small issue.
Lost out. In fact, you have squandered your entire property. You have played fraud with the banking institutions. You take loan of crores. You don't have the capacity to pay. Everything goes bad, and then you involve everybody in all kinds of meaningless litigation. You think we will fall prey to all this trap? Sorry, sir. Mr. Das, this is not, the outburst is not against you.
No, no, I completely understand.
It's your case. Your client
Please,
must have
please.
insisted.
I was only on that small technicality of
Technicality,
being,
technicality at all. You press this technicality and we say that 10 lakhs cost be deposited to the Legal Services Authority. We are short of funds. Legal Services Authority, Assam.
in that case, I'll not pursue this any further.
Please. After some,
But I may be at liberty, my lord, to go before the appropriate forums.
we will not say even that because you have consumed our 10 minutes time. Anyway, we will do that. We have said something. Is it pursuing remedies before the appropriate forum?
I'm so obliged.
After some arguments, Mr. Full name?
Nishan Das.
After some arguments, Mr. Nishan Das, learned advocate, seeks permission to withdraw this petition in order to pursue his remedies before an appropriate forum, if so deemed necessary.
Obliged.
Dismissed is withdrawn with liberty aforesaid, Mr. Das. This is not to dissuade you from coming to this court,
Of course. I'm
but
sorry.
in matters which are arguable.
Precisely.
Yes.
Obliged.
Yes. Mister, you give your appearance slip.
Yes, I have given.
Daily list for hearing, item 13.
May I please your lordship? My lordship, may kindly take up this matter after some time, lordship.
After some time.
My lord, I'm for the respondent. I seek
what?
I seek some accommodation, my lord. Can it be taken up on Thursday, my lord?
This is a review petition.
No, my lord. Initially, this writ petition is against an order of learned Central Administrative Tribunal, where the claim for house rent allowance of the writ petitioner was rejected. Initially, the writ petitioner was allowed. We filed a review, and that earlier order allowing the writ petition was set aside. Now, this writ petition has come up for final hearing, and this
for what period?
for a certain period, my lord. And my lord, this matter was
played for on behalf of the respondent.
yes, my
Number?
lord. The respondent railways, my lord.
As prayed for on
Can
behalf
it be
of
on
the respondent
Thursday,
slash
my lord?
railways. Let this matter come up for consideration on sometimes in March.
5th March, 5-3. Item 15 and 16.
This is juvenility, Mr. Boyan?
Yes, my lord.
We'll hear it after review.
After review, my lord, we have preferred a petition, my lord, wherein for
Application for
Yes. Yes.
considering the juvenility. We could send it, we could decide it. There are many options.
Yes.
We'll do it after the behold.
I leave it to your lordship.
Or otherwise, we immediately proceed to hear the appeal, death reference, if the records are here.
Otherwise, my lord, I am ready.
The statutory obligation is that we first decide the issue of juvenility
Yes, but
at any stage.
yes,
So we will not undertake that. We will take it up on the next stage.
yes, but no issue, my lord. Date to petition.
My lord, in that case, can it be
The first week of February, my lord, after before I will be out of station for
February
few
is
days for
silent.
personal.
Let the upon noted two appeals. Let these cases. Yeah, reference hai. Let this death reference be listed. Death reference with the interlocutory application be listed.
Need it, send it.
For
$10
on 10th.
10
On 10th of
Yes.
10th of
February, my lord. Obliged, my lord.
Item 18 to 49.
अब क्या ये है? ये बाप रे बाप। तो जिंदल Jindal Cements 9 judges bench, but you want from that date for those period. No. So, but later, Mr. Saraf, you will instruct us. You will make us aware of the all position of law. This we shall decide, but otherwise also we would like you to address us on many other collateral aspects of that.
Because many issues have been decided, only one or two issues have been left out by the line judges
What is
bench.
this transport subsidy? Nahi.
No, my lord, that is entry tax.
Entry tax. Now under the new regime, all this
No.
has become irrelevant.
My lord.
So you are asking for that period
But
when the new regime had not actually kick-started.
and the new regime entry tax is not there, my lord.
No. In new regime, this is irrelevant.
Irrelevant.
You are basing your claim for the period when the new regime had not been rolled out.
My lord, my lord.
Nahi hai na?
My lord.
No, Arjun. We'll decide it sometimes in March.
It will take 1 or 2 days, my lord. So
No. If we come prepared with an advocate of your standing, you can let us know only in 15-20 minutes.
I can 15 minutes, but some judgments and etc. my lord.
Judgments, all right, we will see.
My lord.
Mr. Indranil, why you think one day would be necessary? No. Sometimes that it depends how prepared we are and how
If
prepared
it
you
is
are.
disposed of the earliest, I will be happiest person.
How prepared both of you are and how prepared both of us are.
My lord.
Let all these matters be listed for consideration on March after Holi.
17 March.
Yeah. Yes, any change of date?
No, my lord.
दूसरा भी कोई any other matter where you are to argue?
My lord, another matter, last matter is the transport subsidy.
That also you will get later. Your cement company started production later than the
7 days later.
7 days later. You say that it was the electric company played truant.
My lord, my step.
ये भी देखेंगे उसी समय.
My arguments were that, my lord, all effective
March.
My
Item 51, 19 March.
my lord.
Same day we will give you one full day that are Jindal Steel and this.
My lord, if not necessary, I will take all.
Then
I'm
vote
a
the cases on 17.
Separate days.
Item 50.
Yes.
Right. Just kindly peruse the order dated 19/8/2025.
My lord, I have not received my instruction as yet to file affidavit, but then I have to submit something, my lord. May I pray?
You first follow the order and then we will take care of all your submission. You are Mr.
A. Bhattacharya.
Mr. A. Bhattacharya, learned advocate for the
Respond number 1.
learned advocate for respond number 1 submits that he has received instructions and the response affidavit shall be filed shortly. Let that be done. positively after serving a copy in advance to the council for the appellant before the next date, re-notify on February mid-February, last February.
24th February.
Obliged.
And what did you want to say? What did you want to say?
But after filing of the writ appeal, the ex gratia amount has been paid. So no live issue
एक मिनट, तो कब कर रहे हैं?
can be closed.
Ex gratia has been paid to you. no?
Yes,
Yes,
Then why do you press it?
my lord, I have filed the additional affidavit stating,
Anything, he is not
But-
pressing it.
but my lord, we have pursuing the appeal, my lord, because the order passed by the
Forget
single-
about the order. You
Yes,
have got
no.
your share. No. Again,
No.
we are not here for, this is not a luxury ground for, litigation which means nothing. And we are not deciding academic issues here.
Yes.
Again, in view of the, you want to press it? You've got
Yes.
your thing, no?
My lord, for a moment, my lord, kindly
You've
see
got
the,
your ex gratia, no?
my lord, for a moment, my lord, paragraph 17 of the judgment, my lord. My lord,
Mister, we are not interfering here.
but my lord,
Whenever the issue comes, we'll decide.
Yes.
Presently, you have got ex gratia.
Yes, yes.
yes,
In view of the fact that ex gratia payment has already been given to the appellant.
But-
There is no, has already been granted to the appellant. There is no necessity to enter into the merits of the contentions raised on behalf of the parties presently. The appeal has lost its force. We are not asking you to withdraw.
Obliged.
The appeal has lost its force. Dismissed.
but my lord, in pursuance of this,
We are not
order, my
concerned.
lord,
When the situation
other
comes,
case
it
also
appears that
dismissed by the single bench,
you're a
my lord.
veteran at all these ex gratia payments. So let a matter come.
My lord,
And why did you give him ex gratia?
That is, that was thoroughly
and
communicated.
my
to
lord,
the
not only given to me, my lord, other persons also getting the ex gratia, my lord. Usually, my lord, I have annexed the other
All right. Yes.